Before today's hearing even begins, you're about to witness a courtroom session unlike most people ever get to see. What starts as a routine docket quickly turns into a series of surprising legal twists, multiple defendants, unexpected felony developments, bond violations, unusual legal claims, and even someone insisting they're protected by diplomatic immunity. Throughout this hearing, Judge Simpson has to juggle case after case while balancing fairness, courtroom procedure, and public safety, all in real time. Pay close attention to how calmly the judge handles interruptions, how attorneys strategically protect their clients, and how even a few careless words from a defendant can completely change the direction of a case. As we move through these proceedings, you'll see why experienced lawyers often advise clients to stay silent until they've received legal guidance. Some defendants simply need more time, others may be facing additional charges, and a few make arguments that dramatically change the courtroom atmosphere. Which moment do you think will be the most shocking? Stay until the end, because every case teaches an important lesson about how the justice system actually works behind the scenes.
The 14A District Court for County of Washtenaw, State of Michigan is now in session. All those having business before the court draw near. The Honorable J. Cedric Simpson presiding. You're muted.
I know. He's muted, and it's a great thing.
I don't think you realize he's still muted, Judge.
No, he doesn't realize he's a little slow. No.
I'm here now, Your Honor.
All right.
Laura Brown, Deputy Chief Public Defender, appearing. Your Honor, we likewise do not believe that a conflict exists, and we would waive this court hearing all matters before this court today.
Court, for its part, does not believe that a conflict exists either in the Michigan court rules or the cases decided thereunder. To the extent one does, given the waivers, the court will consent to matters. The court does call the case of People versus Jordan Maxey.
Being in Judge Washington's court at the same time as this court, the 7th, but I can manage both of them.
No, you just tell Judge Washington she has to wait.
I will.
Let me know how that goes. All right, which date would you like?
April 7th, please.
All right. Court calls the case of the People versus Jacob Verse.
And Your Honor, I've had a chance to speak with Mr. Ganatra. It's my understanding that there may be some additional felony charges coming down the pipe. So I'm going to ask the court to, yes, Mr. Burst, there's another warrant that's been issued for another felony. So we're going to adjourn the probable cause for that case to catch up.
Okay. Is it already, when you say has it been filed as of yet?
Judge, it was submitted as a warrant request. It's being reviewed by a colleague in my office, and it would be a felony if it's charged as it was submitted.
Okay, so let's do this. I would, sir, what did you want to say?
I just wanted to know what it is.
Well, right now it's nothing. Because I don't have a case, but they're telling me that there may be one coming. I'm not going to have anybody commit to what the charges are going to be. They're still reviewing it.
Okay.
They believe that it may be a felony. So what your attorney's trying to do is just make sure they're all kind of together. Okay. I asked the question that I asked just from a timing standpoint to try to figure out the quickest we could get it done.
Okay, that sounds right. Sorry about that.
No, it's all right. So what I will do is I'll put this out 2 weeks. March 24th, 2022 at 9. If it comes down and they're given another PCC date and counsel knows that, if you could let us know, and then we can potentially do paper adjournment so that we accomplish the goal of having everything together. Okay.
Yes, Your Honor.
24.
That works.
Bond will continue.
The first major takeaway from this hearing is a legal one. Notice that the judge isn't rushing to move forward simply because another possible felony has been mentioned. Instead, he's allowing time for prosecutors to determine whether additional charges will actually be filed, so that everything can potentially be handled together. That's a practical courtroom decision because it avoids unnecessary hearings and keeps the legal process organized. It also shows that speculation isn't enough until charges are officially filed. They're just possibilities. What do you think? Is it smarter to delay proceedings briefly so every charge can be addressed together? Or should courts handle each case separately as quickly as possible?
Thank you.
Thank you. Give me a call, Mr. Burst, okay?
Oh, yeah, sure.
Court calls the case, People versus Robert Cozier. What are we doing?
For the record, Mr. Crozier has been returned to the jail on a bond violation report. I attempted to meet with him in person on Tuesday. However, he's in quarantine. I had a Zoom meeting scheduled with him yesterday evening, but there was a critical incident at the jail and it was on lockdown and all visits were canceled. So I've been unable to meet with him to talk with him. So I'd be requesting a 2-week adjournment. Was that, Your Honor?
2 weeks?
Yes.
Any objection from the people?
No objection, Your Honor.
Probable cause conference will be adjourned March 24th, 2022, 9 a.m.
Thank you.
Thank you, Your Honor.
And we'll continue.
Or
I'm sorry?
am I gonna be able to be released, sir? I've got a job interview coming up. The only reason I was at the house is so I can go
Mr.
through
Crozier?
paperwork.
Mr. Crozier, I will come to meet with you and speak with you about it, but based on the circumstances I read in the police report, I do not believe that Judge Simpson would change your bond today. So we'll need to adjourn.
There was no incident or nothing. There was no incident at the house the night that I was arrested. I was there to get paperwork. She let me be there.
Mr. Crozier, you were not permitted to be there, period. So that is the issue.
Mr. Crozier, I'd suggest that you listen to your attorney so that you don't say anything like what you may have, which already may be an admission to a violation of your bond. So as your attorney is telling you to be quiet, you do need to understand anything you say can be used against you. Thank you. Bond will continue.
Thank you, Your Honor.
Court does call the case, People versus Ivan Pasek.
So, Your Honor, Mr. Pasek would like for me to relate to the court that as a member of the armed services, he is not required to appear before this court, and that he is requesting an immediate release, an immediate dismissal. And there are several other reasons for that as well. I have also submitted some paperwork for Your Honor's signature.
Yes. That is not a basis upon which either jurisdiction of this court would be relinquished or not attached. Being a member of the armed services, there might be certain actions that can't be taken if they are on active duty. However, that doesn't seem to be applicable here. I'm
He is on
certain.
active duty, just so Your Honor knows, because I'm sure he'll let you know. That's what he states, but he also has immunity.
He also has immunity?
Yes, he indicates as an ambassador to 2 countries that he has immunity.
Okay, then here's what I will do. I will order the competency evaluation in this matter pursuant to what was filed with the court. I will set a hearing on that matter for June 16th. I think that's right. June 16th, 2022 at 9 a.m. And as to the request for bond, if he believes that he has immunity under some diplomatic status, I will at this time then continue his bond and await any communication from the State Department. Bond will continue. Thank you.
Thank you, Your Honor.
This exchange is a textbook example of why defense attorneys constantly remind clients not to speak freely in court. Mr. Crozier may simply be trying to explain his side of the story, but every statement he makes can potentially be interpreted as evidence regarding a bond violation. The judge isn't deciding guilt here, he's warning the defendant that even well-intentioned explanations can unintentionally strengthen the prosecution's position. It's one of the most important lessons in any courtroom. Sometimes remaining silent is actually the safest legal strategy. Have you ever noticed how quickly a simple explanation can turn into something far more significant once it's spoken on the record?
Thank you, Mr. Passick.
Court calls the case of the People versus David Grayson.
Your Honor, today is the date and time set for the probable cause conference. My client respectfully requests that we set this matter for preliminary examination. Zoom is appropriate.
No immunity issues? No, I just thought I'd ask so that I don't.
Not this week, Your Honor, not this week.
Okay, all right, I'm just checking. That will be set for March 22nd, 2022, 9 a.m. via Zoom, and that will be before Judge Freshour.
Thank you, Your Honor.
Thank you. Your Honor, if we could just remind the defendant of the bond conditions, no third-party contact, no direct contact with the victim in the case, please.
Is there some indication that that has transpired? Or?
My office received information from the victim that family members of the defendant are contacting her.
All right.
So if you could just reiterate the bond
Sir,
to him, please. Thank you.
Mr. Grayson?
Yes.
Based upon that communication, it would be incumbent upon you and be in your best interest to remind any family members or any people that you know that they should not have contact with the alleged victim and or protected party in this case and not interfere in that regard. That can be, and if you need to have a reason for that, that can be very damaging to you and potentially could lead to additional charges. So that bond condition, there is to be no contact, direct or indirect, or through third parties. You understand that, sir?
Yes, sir.
All right. Thank you.
Thank you.
This bond will continue.
Now the courtroom takes a dramatic turn. A defendant is claiming military status, diplomatic immunity, and protection from prosecution. Rather than immediately accepting or dismissing those extraordinary claims, the judge follows legal procedure by ordering a competency evaluation and leaving the bond in place while waiting for any legitimate verification from the appropriate authorities. That's an important distinction, courts. Rely on evidence and official documentation, not simply on claims made in court. It also demonstrates how judges remain patient and procedural, even when presented with highly unusual arguments. Based on what you've heard so far, do you think the judge handled this situation appropriately, or would you have approached it differently?
Thank you, Your Honor.
Thank you. All right. Court does call the case of People versus Christopher Gilmore.
Your Honor, can I get a breakout room with my attorney?
No.
Mr. Gilmore, we won't be able to do that, but Your Honor, may we approach, please?
Ashley Lonnie for the People, for the record, before we approach.
Can you put Miss Londy, Miss Garrett, and myself into a breakout? Garrett.
I'm trying my case, Ms. Garrett. I'm trying to move forward with my.
If he keeps talking, please mute him. All right, we are back on the record in the Gilmore matter. I think counsel has returned also, has she not?
Yes.
All right. Matter, my understanding is that because of certain incidents that you were not able to communicate with Mr. Gilmore and would like an adjournment of these proceedings, which this court believes is appropriate. So what I will do is I will adjourn the probable cause 1 week since he is in custody. So I'll adjourn it to the 17th, 2022, 9 a.m. His bond will continue.
Thank you,
And
Your
Mr.
Honor.
Gilmore, I will be there
Thank you.
to see you. Thank you.
Thank you. Court calls case, People versus David Epps. All three cases.
Andrew Childers appearing on behalf of the people.
David I. Goldstein appearing on behalf of the defendant in all three cases. Your Honor, as far as the immunity issue is concerned, I am fully vaccinated.
Thank you, Mr. Goldstein.
Here's another critical courtroom moment that many viewers might overlook. Bond conditions aren't just suggestions, they're legally binding court orders. In this case, the prosecution raises concerns that family members may have contacted the alleged victim on the defendant's behalf. Whether or not the defendant personally made contact, the judge makes it crystal clear that indirect communication through third parties can also violate bond conditions. That's why the warning is so serious. Even actions by friends or relatives can create major legal problems if they're encouraged or coordinated by the defendant. It's a reminder that once bond conditions are imposed, every decision matters. What do you think should defendants be held responsible if people close to them ignore the court's no-contact order?
Back on the record, court does call the case of the People versus Jason Maples.
Your Honor, could we have a brief breakout room, Your Honor, Mr. Dowd and I?
With me?
Yes, please.
All right. Can you put Mr. Dowd, Ms. Gaines, and myself into a breakout room? I know why everybody wants to talk to me. And in this matter, there will be, my understanding is there's a request for a referral for competency. The court will refer this for competency evaluation. Court calls the case of the People versus Henry Williams.
Yeah. Andrew Childers appearing on behalf of the people.
Sandra White on behalf of Henry Williams. Mr. Williams, can you state your name for the record?
Henry Williams, right?
Oh, man, Kerry Williams. Oh, I come in at 1:30.
Sorry, Your Honor, got the wrong guy here.
All right, very good. All right.
Here we go again.
Yeah. All right, we'll wait for the jail. Kind of busy there. Court calls case People versus Trevon Pickett. All right, what are we doing?
I've had an opportunity to speak with Mr. Pickett regarding his right to have a preliminary exam. Mr. Pickett has decided to waive his preliminary. Whoa.
I will not be waiving my preliminary exam until I get further of discovery and tell the U.S. Marshals that I'm not making those statements.
All right. He left. Well, he left. Can Mr. Pickett come back, please?
Judge, I apologize. I just met with Mr. Pickett. We had a long discussion. So this is news to me.
It is what it is, bro. I'm not.
Okay, did you want, Mr. Pickett, did you want an exam then?
Yeah.
Okay. You want that in person or via Zoom, sir?
I want it in person. I would like an in-person trial.
Preliminary examination will be March 22nd, 2022.
One thing that's becoming increasingly obvious throughout today's docket is how much courtroom scheduling depends on circumstances outside the judge's control. Jail lockdowns, quarantine restrictions, attorney access, and communication issues have repeatedly delayed hearings. While delays can be frustrating for everyone involved, they're often necessary to protect a defendant's constitutional right to effective legal representation. A court moving too quickly without allowing attorney-client communication could create much bigger legal issues later. The judge consistently chooses procedure over speed, reinforcing that fairness usually takes priority over convenience. Would you rather see courts move faster, even if it risks mistakes, or take extra time to make sure everyone's rights are protected?
9 a.m., that is before Judge Washington. Court does call the case of the people versus Antonio Fuller. All right, what are we doing on this case?
Your Honor, I'm requesting a brief adjournment. I was just assigned this case Tuesday, and I plan to visit Mr. Fuller tomorrow at the jail.
Your Honor, just so the court's aware and Ms. Woodson's aware, if you're not, I received some information this morning from a colleague that Mr. Fuller has assaulted a CEO. That CEO was on his way to the hospital as of the email. That was around 6 o'clock, I believe, this morning. I received it. So I just wanted to make sure everybody's aware.
I am aware of that. I don't know if you were, Ms. Woodson.
I was not.
And my understanding, and I have not received a medical report or anything along those lines, nor would I. I was apprised of that in relation to the PCC docket, as well as counsel's availability to see people, the jail being locked down. It is, at least as I'm apprised, such a circumstance that it would be likely that charges would be coming out of that. And I intend upon taking that into consideration, I'll grant you the adjournment. But I also want you to know that given what I am to understand, and I will give you a hearing on it, should your client so desire. But at this time, because of that, well, his bond in this case is significant. I am going to revoke his bond because the actions would be a violation of his conditions on this case, those actions in their entirety. So you want 2 weeks out?
Yes, Your Honor.
So probable cause will be adjourned to March 24th, 2022.
This sequence perfectly illustrates how unpredictable courtroom proceedings can be. One moment, there's confusion over the wrong defendant appearing on screen, and the next, another defendant changes course regarding a preliminary examination after speaking with counsel. That's actually why attorneys insist on private conversations before major legal decisions are finalized. A preliminary examination isn't just another hearing. It allows the court to determine whether enough evidence exists for the case to move forward. Choosing to waive it or proceed with it can significantly affect the defense strategy. It's another reminder that important legal decisions shouldn't be made impulsively or without understanding the consequences. If you were facing serious charges, would you insist on an in-person hearing like Mr. Pickett did, or would a virtual proceeding be enough?
9 a.m. Defendant's bond is revoked.
Won't drop charges.
Court calls the case of the people versus Jakeem Ware.
Hey, Deputy.
Amy Reiser on behalf of the people, Your Honor.
Senator Erica Julian appearing on behalf of the individual presently identified as Jakeem Ware.
Excuse me, that's not my brother up front.
Mr. Ware, I've been made aware of the fact that you've claimed a mistaken identity. I was unable to meet with you due to issues with the jail this week. I will be out to see you.
Who is this?
I was appointed to your case, sir.
A what?
Now we reach one of the most serious developments of the hearing. The court learns about allegations that the defendant assaulted a corrections officer while already in custody. Although these allegations have not yet been proven, the judge explains that if the reported conduct occurred, it could constitute a violation of existing bond conditions. Instead of ignoring that information, the court revokes bond while preserving the defendant's opportunity to challenge the decision later. This is an important example of how bond isn't guaranteed forever. It depends on continued compliance with court-ordered conditions. A new allegation, especially one involving violence, can dramatically change a defendant's legal situation almost overnight. Do you think the judge acted appropriately based on the information available, or should bond decisions wait until every new allegation is fully litigated?
Man,
He's the attorney.
Did I ask her?
Where?
Hey, Mr. Simpson, Judge Simpson, I've been going through a lot in this jail. And last time I was on your monitor, I don't know what they said to you. They had muted me out. I wanted to
Because
speak
you
with
weren't
y'all.
listening. No, I had you muted because they didn't do that. I did that
Okay.
because you weren't listening to me.
No, listen though, I was trying to explain to you this facts and the stuff that's going on with this situation. Most of the stuff that you said never even happened. My brother was never on tether. None of that stuff. My brother was never on tether. And some of the dates is confused. He was with me in certain places. I don't know what they just said to y'all or what you just did. Was that you talking?
Sir, I was only arraigning you. I was apprising you of the charges. I was also apprised you that the issue regarding identity certainly can be a defense to the case. But I was also letting you know that based upon the extradition, I was satisfied with that I had the person that was named in the complaint before me. At that time, I then apprised you of the charges. I apprised you of the maximum penalties. I asked you whether or not you understood those.
No, sir.
You chose not to answer my question, I believe, on 2 or 3 occasions.
They muted me though.
No, you would not answer my question because before you were muted, you would not answer my question. I told you how I wanted you to answer my question in terms of either a yes or a no. You wanted to go on and explain something else.
Okay, well, listen.
I was satisfied that you understood the charges. I was satisfied that you understood and had been apprised of the maximum penalties.
No, sir.
And I indicated that you were then standing mute to the charges and not saying anything.
I didn't do that.
Therefore,
No, sir.
for your protection, I then entered a not guilty plea. I set the matter for probable cause conference today.
Hey, bro, this ain't no court date.
And then set it for a preliminary examination so that we did not have to go through any type of waiver. I said all of that at that time. And I am still convinced that
we're now entering the most emotionally charged portion of today's hearing. The defendant claims he's been mistaken for someone else and insists the case involves his brother rather than him. Mistaken identity is a legitimate legal defense when supported by evidence, but it's not something that can be resolved through argument alone during a preliminary hearing. The judge's responsibility at this stage isn't to determine guilt or innocence, it's to ensure the case proceeds according to the law while allowing both sides the opportunity to present evidence later. Watch closely as the conversation unfolds, because this is where courtroom procedure and raw emotion begin to collide. If you believed you had been wrongly identified, how would you try to convince the court while still following courtroom rules?
You understood the proceeding that you were going through. Miss Julian,
I did not proceed, wish to proceed. I did not do none of that.
Mr. Ware, whether or not you state that you're your brother, would you acknowledge that your last name is Ware so I can address you properly?
Did you say you my attorney?
Yes.
Can we adjourn this so I can speak with you personally?
Absolutely. I would love to do that.
That's what you said 20 minutes ago.
2 weeks. I'm requesting
2 weeks?
Yes, Your Honor.
Yes, thank you.
Probable cause conference will be adjourned to March 24th, 2022 at 9 a.m. Continue. Thank you.
Thank you.
Excuse me, Judge.
That's it.
No, hold on. Excuse me, Judge, with the attorney.
Mr. Ware, as your counsel, I recommend that you cease addressing the judge at this time. I will be there to see you as quickly as possible. I tried to see you twice this week, but there were issues with the jail. So I'm going to see you as quickly as I can, okay?
You said it was issues with the jail?
I'll explain all of it to you when I can meet with you.
No, I do not want to be. You said two weeks later, and issues with the jail, them telling me different times and dates, issues with the jail of them leaving me in this cell, don't let me get in the shower or nothing, issues with the jail of them saying I'm denying everything that come in this jail or phone calls and stuff like that. Can you make sure?
Mr. Ware, if you could please stop. You are in quarantine, so I was not able to meet with you in person. And then there was a critical incident at the jail last night when I had a Zoom meeting scheduled with you that canceled all visits. It was not personal to you. I will be out there as quickly as I can to meet with you. I promise, okay?
Okay, well, can you explain this to me?
I will explain everything when we meet.
No, they had a guy in this jail. He had the same outfit I had on. And one night, and he got out the jail, the time that I was bonded, I was supposed to be getting out the jail within 72 hours.
I will hear all of your concerns as soon as we meet, and I will address every single one.
Who just said their name was Reisner, though?
This exchange perfectly demonstrates why judges insist on direct answers during formal court proceedings. The defendant wants to explain his entire situation immediately, while the judge repeatedly emphasizes that the earlier hearing was simply an arraignment, not a trial. During an arraignment, the court informs the defendant of the charges, explains the maximum possible penalties, protects constitutional rights, and enters a plea if necessary. It isn't the stage for presenting evidence or arguing the facts of the case. That's why the judge keeps bringing the discussion back to simple yes or no responses. It's not about refusing to listen, it's about following the legal process in the correct order. Have you ever noticed how courtroom procedures can seem strict, even when both sides believe they're simply trying to explain themselves?
Mr. Ware, your hearing is complete. I'll be out to see you shortly.
Are you
Thank Judge
Reisner or
Simpson.
Julian?
14A, District Court stands in recess. Thank you. You're welcome, ma'am. Court calls the case, People versus Martin Wise.
Ashley Lonnie for the people.
Mr. Wagner, you're muted. This is going to take a minute. Joe, it's the one with the microphone.
Good.
There you go. You got it.
Good. Thank you. Hey, you know what you're dealing with here.
Yeah, I got it. Like I said, I was letting everybody know it's going to be a minute. I think
Okay.
Ms. Lonnie aged a few years. Go ahead.
Never, Your Honor, never.
What are we doing on this?
Your Honor, defense counsel reached out to me by email yesterday afternoon. Unfortunately, I was not able to return his message, so I was asking for an adjournment so he and I can discuss the case and possible resolution.
All right.
I'm in agreement, Your Honor.
All right. Would you like 1 or 2? Well, you'd like 2 weeks. Will that work for
2
you?
weeks would be fine.
All right. Probable cause conference will be adjourned March 24th, 2022, 9 a.m. Bond continued.
One of the biggest themes throughout today's docket has been communication or the lack of it. Several defendants have expressed frustration about quarantine restrictions, canceled jail visits, delayed attorney meetings, and limited opportunities to discuss their cases. While those concerns are understandably stressful, defense attorneys consistently remind their clients that the courtroom isn't always the best place to argue every grievance. Instead, legal strategy usually begins with private conversations between attorney and client before those issues are raised formally. Judge Simpson also allows counsel the opportunity to meet with the defendant before moving forward, reinforcing the principle that effective representation is essential to a fair process. This exchange is a powerful reminder that patience, preparation, and communication often shape the outcome of a case just as much as the evidence itself. What an eventful court session. Across multiple cases, we saw nearly every aspect of the criminal justice process unfold in real time. Potential new felony charges, bond violations, requests for adjournments, competency evaluations, mistaken identity claims, disputes over courtroom procedure, and repeated reminders about defendants' constitutional rights. Throughout it all, Judge Simpson focused on maintaining order, ensuring due process, and giving both prosecutors and defense attorneys the opportunity to properly prepare before critical decisions were made. The hearing also highlighted an important lesson for anyone watching. Every statement made in court matters. Bond conditions must be followed exactly, and legal procedures exist to protect the rights of everyone involved, not just to move cases along quickly. If you found this courtroom breakdown insightful, let us know in the comments which case surprised you the most and why. Did the judge make the right calls throughout today's docket, or would you have ruled differently in any of these situations? Don't forget to hit the like button, share this video with others who enjoy real courtroom proceedings, and subscribe to the channel for more in-depth legal breakdowns, dramatic courtroom moments, and fascinating case analyses. We'll see you in the next courtroom session.